Hi, it's Monday, December 19th at 5 p.m., and Lester Perling and I welcome you to our webinar entitled 17 Advertising Commandments. This is a very important webinar because we have had so many clients find out that they are out of compliance with Florida's many physician advertising rules. And Lester has, for those of you who don't know who Lester The second big mistake would be to break any state or federal law which prohibits payment for a referral. And that can be any sort of payment. That can be direct recognition by a sports ticket. That can be something that I see often in optometrist offices: refer a patient and get a free eye exam. I can't believe they don't know not to do that, because that's are tempted or advised to advertise that they were recognized by as some sort of a specialist, when in fact what they did was they went to a 2 or 3 week seminar given by a reputable company, and they really tried this on themselves and a few friends. And yes, they may know more about it than almost anyone else in the community, but that's not going to be sufficient for you to refer to yourself as a. Fourth is conveying the impression that the doctor has any qualification, skills, or other attributes that are superior to other doctors. You can list your postdoctoral achievements, you can list your board certifications, you can list specific professional achievements, but you can't say that Dr. Smith is the best doctor in the community when it comes to anti-aging or anything else like that. Lester, do you have any comments on the first 4 mistakes? And of course, we're going to be coming back to these when we finish our 8-minute round here.
I'll save my comments till you get through those and use your 8 minutes, and we go through them in detail.
Okay, that's good, because that means that I haven't made any mistakes on the first 4 mistakes. Okay, the 5th mistake is failing to That would be mistake number 6. Mistake number 7, if you are a walk-in clinic or you take patients for what I'll call urgent care, which may mean unscheduled care, if you allow walk-ins, then you have to have the schedule of fees in a 15 square foot size sign in a conspicuous place in the reception area. If you fail to have that with the 50 most frequently provided services and the price list as specified in the materials that you're receiving today, that's going to be mistake number 7. And then mistake number 8, which I think is going to be also a very, very large mistake for people who make it, is the failure of your practice to register as a pain management clinic if you are on your website that you are a pain management clinic, or that you help people with pain, or that you treat pain, or anything associated therewith. Because if you do that, then you are in all the pain management clinic rules and registration requirements that I'm sure you are at least somewhat aware of. So Lester, any comments on that before we go to the actual text of the... It's not. By the way, Lester is in New Mexico, where, unbelievably to me, they've had 6 inches of snow where he is today. So if we lose Lester, we'll forgive it to the snow.
No, I'm here. I was just I'm muted because I was coughing. But no, I'm
okay.
very impressed. I'm very impressed that you got through that in the actual 8 minutes allotted.
Oh, thank you very much. I appreciate it. I have to talk fast, but I'm used to that. Okay. And I've listed the commandments here on the first page, and on the second page, and on the third page, but I'm just going to go directly to the first commandment, which is, thou shalt not violate the Florida Patient Brokering Act or the Medicare Anti-Kickback Statute by paying or receiving any direct or indirect remuneration for the referral of patients. Not even $1 can you pay to somebody to refer or send a patient to you, with very few exceptions. Now, one of the exceptions that Lester's going to talk to us about is the payment to a marketing company or an employee where there is a legitimate arrangement. You may be able to pay an employee of your practice to bring patients in. Able to pay marketing companies to advertise for you and to market for you, but you cannot pay them in relation to what they bring in. So Lester, do you want to talk about that a little bit?
Sure. I think, Alan, when you just sort of summarize that, you kind of put commandments 1 and 2 together, which is fine. I can talk about them in that way. One is specifically addressing, which is, I think, remuneration or payments within the group practice itself for referrals within the group, such as a physician employee who might order an x-ray that would be taken and billed by the group, or some other type of ancillary service. The Florida law governing fee splitting actually prohibits employee in a way that would induce the employee to refer patients within the group. So, for example, a bonus based on all of the revenue generated by the employee, the employed physician, which included the x-ray revenue, would be a problem under Florida law. And that issue was addressed many years ago, and went all the way up into an appellate court, and was found an employee, or for that matter an independent contractor, can be compensated based on their own personal services, things they actually do, or physician extenders services, people who they are responsible for supervising, but not for things they merely order. So that would include x-ray or physical therapy, or referring to another physician in the group who has some specialty that this particular employee doesn't have. Payment prohibition against, if you will, advertising within the group for group members to refer within the group. So those types of compensation arrangements need to be carefully looked at because they can cause a problem under the fee splitting statute in Florida, but they can also be a problem under the Medicare Stark law, which we're not going to talk about, but just developing employment compensation arrangements or compensation arrangements related to independent contractors, you need to be very careful. And independent contractors are treated differently than employees because under the Board of Medicine's view of the world, anytime a patient calls a clinic and is scheduled to see an independent contractor rather than an employee, that's considered a referral. Is independent, different than an employee. And so the compensation rules within a group practice for independent contractors are different than employees because of that aspect of the referral. I'll save, Al, until Second Commandment till we talk about sort of the other type of external marketing relationships in case you want to add this itself.
Well, actually, the Second Commandment is advertising in a false way. So do you want to go ahead and talk about the patient referral?
Sorry.
Yeah, the commandments don't fit the 8 mistakes.
Oh, okay. I apologize. So let's talk then about payments for referrals from outside the group. So you have 2 categories potentially of people you can pay. Is unclear under both state and federal law, but the federal safe harbor for that sort of arrangement for employment relationships is fairly broad, and Florida law generally is going to follow the federal law. So something like a bonus to a bona fide employee if they refer a neighbor or a family member might just be permissible. Time works for the practice, doesn't work for anybody else, and goes out and tries to generate referrals on behalf of the practice. Probably a form of a bonus based on their production, something like a commission, might be acceptable, and the Office of Inspector General on the federal level has kind of left that door open. We generally advise clients in that situation be a reasonable base salary and then perhaps a bonus based on either the profitability of the practice in total, which is the safest way to do it, or even the employee's own production could be bonused, understanding that there's a little bit of risk potentially, but that it's not per se illegal. And again, those types of relationships all need very careful scrutiny because even though the line what might be considered safe. In terms of the outside relationships, that's pretty clear. If you're contracting with an independent contractor or a marketing company to market your practice, you cannot, and underline not, pay them in any way that varies with the amount of business they generate. That's a pretty well settled point of law. So that's a pretty easy one. They have to be paid a fixed fee in the aggregate that doesn't vary with the volume or value of their referrals. Or, and keep in mind, in the kickback statute, at least under the federal statute, a referral is one thing, but it also covers recommending referrals or arranging for referrals. And certainly marketing representatives, if they're not doing anything else, they are recommending referrals. Or it held that a commission-based payment arrangement was in fact an illegal kickback arrangement.
Wow. What did that client go through in having to defend that situation?
Well, that was actually, in that case, the client came to us after entering the relationship. Our client was a healthcare provider, and for whatever reasons, they had become doubtful about the legality of it and asked us to opine on it. Recommended that they terminate the contract, which they did. The marketing company sued them for breach of contract, and we defended based on the fact that the contract was illegal under the, I think at that time we only used the federal anti-kickback statute, although we may have used state law as well. And the courts agreed that it was clearly a violation and that the termination was proper, and they had no authority to enforce the agreement because it was a way for the court to amend that compensation term to make it legal because they're not going to revise the contract. And then after our case, there were 3 or 4 similar federal cases that went the same way. Our suit happened to be in state court. I think there was another state court case. So that's a pretty clear-cut area of the law.
Yeah.
And then you've got the relationships with referral sources, like Alan mentioned, sporting good tickets. Somebody to whom you may refer patients says, oh, I appreciate your support. Here's some 4 box seats to the Tampa Bay game and a parking pass and a gift certificate for $200 for dinner. We really appreciate it. That situation, you want to say thank you, but no thank you. And you don't want to be in the situation of offering such a thing either.
Situations, and I've had many years back clients who, for renting space to a blood lab for $250 a month, paid over $100,000 in legal fees to defend the situation. And one client who lost his Medicare abilities just because a blood lab employed a relative of his, and the relative didn't do very much. So it's just not worth risking your whole career over, especially if there's federal money involved.
The second example that you have there, the civil example, we actually represented the doctor in that case. And I can tell you that the vast majority of the doctor's services that the government was complaining about were, in our opinion and in the opinion of most others, defensible.
Wow.
And services the doctor rendered and was paid in what appeared to be fair market value way. I mean, there were some others that might have been a little bit grayer. The government was just not going to hear about it. And So the potential penalty if the doctor didn't settle for what seemed, it's an awful lot of money, if the doctor had litigated it and lost, would have been significantly greater than that. And he probably would have been excluded from Medicare, which didn't happen in the settlement. So, it's a tough environment out there.
Yeah, you can't be too careful. Okay, let's scroll down here to the next commandment. This one's an easier one. Thou shalt not advertise in a manner that is false, deceptive, or misleading. Well, I don't think we have too much to talk about with this. You just you want your advertisement to be very realistic and not at all misleading or stretching. Anything to say on that one, Lester?
Just that, it's the whether or not an ad is misleading or deceptive is in the eyes of the beholder, much like pornography is. And I'm actually representing a practitioner now that owns a number of clinics who's being investigated by the Attorney General's office for alleged deceptive trade practices. And the advertisements that are at issue are, and to my thinking, not deceptive at all. In fact, they have very specific disclaimers. So you really, in preparing an advertisement, get second and third opinions, from people in terms of just sort of do some sort of test. So you're not, you don't write the copy of the ad or your ad person do it, and then you put it on air. Get sort of some just reasonable people out there, your spouse, your neighbor, whoever, to look at it and sort of quiz them about what it means, because it really can be a problem, even though in your mind the ad is completely clear cut. Yeah.
So you can show that you maybe even pay an expert in that area to peer review the ad to help make sure that it is not deceptive, at least from a medical performance standpoint.
Yeah,
and of course,
that's a good idea. So even though this is a fairly straightforward one, it's kind of a little bit of a trap for the unwary, just because of the subjective nature of it.
Right. Now the third commandment looks a lot
what you're putting out there doesn't create one of these issues, and keep in mind that it doesn't mean you can't necessarily use that copy, but you might have to think about the disclaimers that you have to put in the ad as well.
right, and it's okay to have the large print giveth and the small print taketh away, as the Tom Waits song says. Okay, now the fourth commandment, and this is one that Lester and I have had some first-hand experience at, unfortunately, is that you can't
they accept and don't accept. And I can't tell you what all the specifics are, but the rules lay it out in a fairly straightforward way in terms of what they accept and not accept. And you can always check with the board if you have any uncertainty about whether or not your board, if you have a board or some sort of specialty designation, is recognized. I think an important point here that your ads are going to be scrutinized by your competitors, particularly in those specialties that do a lot of advertising, like Alan mentioned, anti-aging or weight loss or pain treatment and things like that. Your competitors are watching what you got in your ad, and I think what Alan and I are both seeing is they're not afraid to rat you out. Know that the investigators for the Department of Health, they look at these ads, and I have seen several cases that were not the result of a complaint from an outside person, but resulted from the Department of Health investigator himself or herself who saw an ad and found it to be deceptive, or found that the specialty designation was not a recognized specialty. So lest you think that there is nobody watching, I've seen a significant uptick in the past 6 months to a year of competitor complaints with regard to ads. So it's not just a matter of the government coming and looking for you. You've got a lot of other people who are paying attention to what you're doing.
I agree, Lester. I think we're seeing a lot more physicians advertising because it works. I mean, physicians can really drive volume to their practice by advertising. A lot of people who are turning in their own colleagues anonymously, and it's unfortunately it's an effective tool. And when big mistakes are made, it's probably good for the public even. Okay, going down now to the next commandment. And by the way, underneath each commandment, we have the law that applies, and then some examples of what the Board of Director of Medicine has done to people, and what other governmental agencies have done to people who have not complied with these rules. And again, the fifth commandment is very similar. You cannot refer to a specialty certification unless you include the name of the specialty board that awarded the specialty certification. So you can't just say, is board certified? You have to be very specific in the advertisement as to what board certification you have. So Lester, can I go to the sixth commandment?
Please do.
Skills or attributes that are superior to other physicians. And I mentioned this as one of the big mistakes. Lester, do you have anything to add to this?
A little bit. This is another one that unfortunately is in the eyes of the beholder. But the thing you need to think about is, there are obvious words like, hi, I'm Dr. Jones, I'm the best orthopedic surgeon in St. Petersburg. anybody else.
Okay, very good. All right, onward to the 8th commandment. Always put your name in the advertisement. You can't just use a trade name. You have to put the doctor's name in the advertisement so that you are, in effect, standing behind what you say. Any comment on that, Lester?
I think that's pretty straightforward.
Yeah, okay. Then audio tapes or videotapes of any advertisements that have gone through electronic media for at least 6 months for MDs or 90 days for osteopaths after it's been aired or shown through the electronic media. And I guess probably they weren't thinking about it at the time, but you probably need to keep all your website information intact for those 6 months as well, which shouldn't be too difficult if you just run a copy of the website as you continue. It is a very important place to check for all of these violations and a very easy place to slip up. It's really easy to be adding something to your website that inadvertently breaks some of these rules. So let's be very careful with websites and similar electronic, maybe even your Facebook page and those types of things you have to be very careful with. Anything to add on that, Lester?
The board considers basically all of that social media to be, or Twitter, any of those things that you think you're innocently writing something on, if it's your Facebook page or your Twitter account or whatever, the board is probably going to consider to be advertising.
Yeah, you have to be very, very careful on everything you do. Okay, now the 10th commandment. And Lester, I'm just going to let you talk about this and even how you want to present what this commandment is and what it means to people.
Service right now, at least in some circles, is, and Alan mentioned, 1-800-ASK-GARY, which probably everybody that's listening is familiar with, is one type of referral service. There's a lot of different types, however. Some of which don't really fall into the category of being necessarily controversial. For example, hospitals often run physician referral services and generally do them quite well. Referral services that are done pretty well and are not particularly controversial. Now there is in the Patient Brokering Act, which is a Florida criminal statute that prohibits payments for referrals, there is an exception that actually protects payments related to physician referral services that meet certain criteria. And I think materials. But then you have the other type of referral service, such as Ask Gary and others, that have become very controversial because they become something more than just a straightforward physician referral service because of their ties to attorneys, particularly in the personal injury world. And those have, and as you probably have seen in the press in the Tampa Bay area and other places, even nationally now, are coming under significant amounts of scrutiny. So I guess without getting into really gory details, you need to carefully, if someone tries to promote a referral service to you, or you are thinking of joining one that you've seen, you need to be very careful about who's behind it, how it works, how does it actually dole out its referrals, payment arrangements, all those types of things, because they do pose a fairly significant degree of risks. In the hospital setting, for example, there are no payments. They just sort of refer people to their medical staff in a way that generally, is a rotational system or geographically based system that isn't much of a problem. But there's a lot of traps for the unwary, and there's a lot of things now that maybe call themselves referral services but are really something else altogether, and in some cases just straight out payments for referrals. There are some referral services that are using runners, or what purport to be referral services that will rush to the accident scene, and they get paid for every patient they generate. You don't want to get involved with one of those. So you need to be very, very careful about, entering into one of those relationships. Like I said, and there's others that aren't so clear, but I really recommend that you carefully determine how the referral service works, and if you smell something a little bit fishy, make sure you get it checked out by a competent attorney to figure out if the way that service operates is going to cause a problem for you or not.
Just amazing how people get themselves and others into trouble sometimes. You have to clearly identify yourself as a medical doctor or a physician assistant or an anesthesiologist assistant or an osteopathic doctor when you're disseminating information or working with a patient. Do you know anything about this one, Lester?
Yeah, I mean, this applies to chiropractors as well. And basically, a lot of some of this sort of harkens back to the days when osteopaths weren't equal to MDs, and the boards wanted to make sure the public wasn't deceived by someone calling themselves Dr. Jones. And they knew the actual credentials and theoretically the training. I mean, that's still sort of what's behind the chiropractor rules, because the Board of Chiropractic Medicine doesn't want chiropractors to call themselves merely Dr. Jones, and they're not. So it's really, again, about not advertising deceptively. And that would be the reason for saying, yeah, I'm a nurse practitioner, I'm a physician assistant, whatever, so people don't think that you're a physician.
So you do have to have a tag on everybody's name in the office? Is that the
I would do that as well, yeah. Yeah.
Okay.
I don't know that rule, this rule particularly, it's always good for patients to know who they're dealing with.
Right, and to not think that everybody who wears a white coat is a physician.
I mean, it might say Mary, nursing assistant without their last name, but they know who they're dealing with.
Right, right. Okay. Then the 12th commandment is you must disclose all variables affecting a stated fee if you advertise a specific fee for a service. In other words, you can't do this as a loss $, but the bandage is another $600. You have to make sure that you very thoroughly describe what the patient is going to have to pay for and what all it entails if you're drawing them in with a price. Is that correct, Lester?
Exactly. I mean, again, this is another just rule really that relates to deceptive advertising, that we've all been burned by in all kinds of products. Not the real price.
Right, right. By the way, if anybody has any questions or comments, please just send us an email, or you can type a question in on the screen there, and we'll be glad to answer it. Okay, the 13th commandment, and that is if you are offering free or discounted services, you must have this all capitalized language in your advertisement. It needs to be prominent from responding to change their mind. Any comments on this, Lester?
No, again, it's pretty straightforward, although physicians often forget it, and particularly where I've seen problems with it, it's been in the Facebook page, where things they don't think of really as being advertising. And the 72 hours is like a lot of other consumer contracts back out of the deal. So it's fairly consistent with all types of consumer services.
Okay. Now the 14th commandment, and this goes to the new price posting law, and that is if you are considered an urgent care center or an urgent care facility, then you have to post your prices. Now, a lot of physicians are finding that they do have the opportunity to offer more flexible evening hours, or welcome, or letting patients know that they can call if they have a problem, come to me, don't go to the emergency room. Lester, how does this rule work as far as what the definition of an urgent care center is and what the consequences are if you have this going on and you don't have this 15 square foot sign in your otherwise beautifully decorated lobby?
Well, the definition of urgent care center is as an urgent care center, which is like a if you will, mini emergency room. It can easily encompass a physician's office because, as you said, Alan, if a physician advertises walk-ins, they're probably going to be considered an urgent care center. It's basically, I don't recall the exact wording, but where people can receive care on a more or less but a walk-in system would certainly work. Even something like, where patients can call in and you advertise same-day appointments or something like that could be, although if an appointment is made as opposed to a walk-in, I think there's an argument that it's not an urgent care center. But again, it's a broader definition than what the common. In terms of the penalty, Alan, I don't actually remember. I know obviously disciplinary action. I don't think it was a misdemeanor, but maybe you remember different.
Yeah, I don't recall. We'll have to fill that. We'll have to do some more writing here because we have not put the law in specifically. But I see it's a $1,000 per day fine. That's big enough fine penalty for me to not want to break that law.
And again, this is something. Smith is advertising walk-in hours. Let's go see if we can get him in trouble and see if he has his prices posted.
Right.
So.
Okay. Then the 15th commandment, you have to disclose your license status if you're an MD or an AA. Lester, what is this about? I think this kind of relates to what we were talking about.
This is what you mentioned before, Alan, the name tag. So if they're not speaking to a nursing assistant like they would a physician or a nurse practitioner or something of that ilk. And also so they can question if they think they're getting, if the nursing assistant is giving the medical advice, they can question, gee, that doesn't seem to be legitimate to me. Own 2 cents. So
right.
But that's all it's about, really.
Okay, and then the final commandment, which we're going to cover at length tomorrow at 5 o'clock, and everybody here is welcome to join us, is that you cannot advertise pain management services unless you register as a pain management clinic. So Lester, do you want to talk about maybe just about 2 minutes on this, and then we'll let everybody go home, and then we can talk to people again tomorrow at 5 if anyone's interested.
Yeah, about 2 years ago, the legislature required what they call pain management clinics to register, and now they require that. Well, it's still registration actually. And the gotcha in this particular issue is what a pain management clinic is and what it isn't. All right, do you have chronic pain, low back pain? We can maybe help. We do all these great procedures, and we're board certified in this and that. Well, you're not advertising for drugs, but you've used that word pain in your ad. And that mere fact makes you a pain management clinic that has to register and follow all of the rules that govern pain management clinics in Florida. So it's a really easy trap to fall into. And the Board of Medicine, a few months ago now, issued an advisory opinion in which it looked at several hypothetical ads, yellow page ads, billboards, other types of ads, and was asked, would this be considered an ad for pain management or not? And responded accordingly, and ads that were clearly for something other than pill mills were still deemed by the board to be advertisements for pain